Okay, everybody, it's freshly 2 o'clock, so we're going to get started. This is Victoria Coolbaugh, NJA's Executive Director. I will be moderating this call a little bit, but our main moderator is Alison, Braiser, who is an NJA Board of Governor and a Citizens for Justice trustee. She will introduce our speakers and get this conference rolling. Alison,
okay. Hi, everyone. Thank you for joining us today, and thank you especially to all of our speakers who, like us, are trying to navigate these ever-changing circumstances and realities that we're all facing, and we really appreciate all of them taking the time to help us understand what's going on and to make sure that we are following the governor's directives and making sure that we're doing the best job we can for our clients. So some people have submitted questions ahead of time, so those have been passed along to our speakers before the call. But except for speakers, everyone will be muted. And if you have a question, what you need to do is hit 5 star. And when you are unmuted, then you'll hear a little chime that says line unmuted, and you'll be able to ask your question. Please know and understand that there's some questions that our speakers might not be able to answer, or that they, none of us know the answers to. So please be respectful with your questions and understand that we're all dealing with this as it's coming along. So I'll just get it kicked off and introduce our speakers, and then give them each a few minutes to kind of talk about the different directives and how they see things playing out from their respective roles. So we have on the line with us Attorney General Aaron Ford, Chief Justice of the Nevada Supreme Court Chris Pickering, Chief Judge of the 8th Judicial District Court Linda Bell, and Chief Judge of the 2nd Judicial District Court Scott Freeman. So Attorney General Ford, do you want to kind of kick off the conversation?
Sure. Thanks so much, Alison, and thanks, Victoria, for setting this up and for reaching out. I have to check my clock. Good afternoon, everybody. The days are running together, and we are busy over here at the Attorney General's office trying to do the best that we can to offer assistance to Nevadans right now due to this COVID-19 crisis. As I understand it, I was asked to join the call to talk about, I believe, a specific directive, but maybe additional questions about other directives. On the line also is my Special Assistant Attorney General, Teresa Har. Not certain if she has been given the speaker's privilege, but I would like her to have it so she can likewise chime in where necessary. But we are capable to, here to answer questions that we can. Some we may not be able to, as Alison indicated, but we'll be able to try to help out as much as possible. So thanks again for arranging this, and I look forward to the conversation.
Chief Justice Pickering, do we have you on the line?
Yes. Can you hear me?
Yes, we can.
Good. I had a little trouble logging in. Thank you for convening this and giving us this opportunity to hear and hopefully answer at least some of the questions that people have. These are truly challenging times, and as Chief Justice, I'm working with the District Court and limited jurisdiction judges across the state to address the crisis that we have in our courts and community in the face of the COVID-19 virus. There is no map or script for this. I think everybody in the state, in the court system, is doing the very best they can to manage this, and I believe the Attorney General and the Governor are too, and everyone is working as cooperatively as we possibly can. I understood from the questions that there were concerns about several of the governor's directives, and there was a revised 009 that was entered that clarified the governor was addressing only statutes of limitations and the commencement of actions, not the rules of court and other matters that it could be read more broadly to have addressed. And the governor's original guidance that went with that directive made that clear, but he amended it to make it crystal clear that he's talking about the statutory piece of a statute of limitations, which I don't think the courts can suspend statutes. I think, the governor is exercising his emergency authority to suspend the statute, but it's up to the courts on the other issues that lawyers and parties are facing. And I want to really give a shout out to the chief judges of the 2nd and the 8th. Linda Bell has been doing an amazing job navigating all the different complexities that have arisen, and so is Scott Freeman, and we're really in their debt. And I'm happy to answer any questions people have that I can answer.
All right. Thank you, Chief Justice Pickering. Chief Judge Bell, do you want to give us, I know there's probably much different realities and complexities between the 8th Judicial District and the 2nd Judicial. So if you want to give us, if you could, a perspective of what's happening in the 8th, and then we'll hear from Chief Judge Freeman about what's happening in the 2nd.
Sure. First, I want to thank Justice Pickering for her leadership during this time. She's been incredible to work with, and we're very lucky to have her at this time. We have been working very hard to try to provide guidance in all of the case types that we handle. So there was an administrative order issued, I think it was about a week ago, relative to March 20th, it seems like about a year ago, relative to civil matters to try to provide some clarity. I know as we issue these administrative orders, lots of questions come up, and I'm happy to answer those questions. We're also working very hard to completely automate our court. We're not accepting any paper, and we're working through some processes that we will streamline in the next week or two to make it a little easier for everybody, and I appreciate everyone's patience while we're working through all that.
All right, Chief Judge Freeman, can you give us a perspective of what's happening in the 2nd Judicial District?
Of course. First of all, I would echo Chief Judge Bell's comments related to Chief Justice Pickering. She's been a leader, and when all of us found ourselves on the roulette wheel and our numbers came up to be Chief Judge, nobody told us that we'd be the Chief Judges and Justices through a pandemic, which changed the entire justice system in our state. And so we're very lucky that Justice Pickering is, as they say, quick on her feet and working to make as many things uniform throughout our state as she can. Now, to that end, I share with you that in the 2nd, we're balancing the current health crisis with the ramifications of our orders. In the next week, I'll be issuing another administrative order modifying essential hearings to allow some of our judges in the civil arena to be able to move their cases forward as they deem fit on necessary and essential issues in your respective cases. So they're not going to be hamstrung to a tremendous degree to my original, I think it was Administrative Order 2. So I'm going to work with presiding family court judge Rob, myself, and Vice Chief Lynn Simons in the 2nd. And we're going to be looking at cases that we can allow to move forward in a more reasonable manner, keeping in mind that someday the pandemic will resolve itself, and we don't want to be at the back end of having a tremendous backlog of cases that all of a sudden have to have resolutions. But I have cautioned my court as recently as today in a 2-hour judges meeting to balance in each department the ramifications of the health crisis as they move cases along, i.e., think about assembling lawyers and potential witnesses and clients by Zoom and other places that may not be able to be accomplished. So think about the ramifications of those circumstances, and if you can't answer it to your satisfaction from a health perspective as a priority, continue the case. And so that's kind of the message from the 2nd.
Thank you, Chief Judge Freeman. Attorney General Ford, I think maybe we could start off. The original intent of the call was to talk about the governor's Directive number 9 that came out yesterday, and we know there was a revision that came out subsequently. Can you just speak about kind of the process of how these directives are coming about and how you see them progressing and ultimately being enforced?
Sure. So the directives themselves are coming out. There's some method to the madness, but not entirely, because as things progress and develop, the governor has to consider new issues and new items. This pandemic, when I first heard about it, I happened to be out of town when we had our first hit. I think it was March 1st, and by the end of March, on March 31st, we had a 1,000-fold increase in number of folks who have been infected. So this is moving fast, and the governor's having to marshal every resource and ability that he has under NRS Section 414 to address this. And under that statute, the legislature has expressly authorized and given to the governor the ability to essentially do anything within constitutional bounds to help mitigate this disaster. And under that particular directive, what he has done is issued directive with a capital D, directives that relate to certain issues, whether it's people being able to gather in places larger than groups of 10, whether it's now most recently requiring folks to stay at home except for essential travel, or whether it's dealing, as he did on yesterday, with the dearth of resources we have in the medical community and allowing folks who have been either retired with a license here in the state or having licenses in other states living here being able to be utilized to help out. So these directives are sometimes directed at a particular issue, other times it's anticipating issues. This one in particular, directive number 9 that I was initially asked to talk about, was one that he intended to address a few issues, one of which is the statute of limitations. And I think Justice Pickering said it best in the way that she described it. It was intended to be very narrow in what he was trying to do, and that's essentially to say the statute of limitations for commencing causes of action were being told. He has the authority to do that under NRS 414, which has not only specific provisions but catch-all provisions that allow him to do that. And I've seen one of the questions in there was what authority the governor has to do this. And rest assured, the Attorney General's office stands ready and willing and able to defend his authority under these circumstances. And so he's doing that because he doesn't want people to lose out in their opportunity to go to court to pursue a cause of action that they believe they are entitled to. It was not intended to, and hence the reason for the amendment, to affect other things that are strictly within the court's purview. You've heard the justice and judges also talk about some of those things, including court rules and whatnot, and so that's what Directive 9 is limited to. What I see coming down the pike, I frankly can't state. We are working with the governor as best as possible to be able to advise him on issues. And also helping to draft, when asked, particular documents that relate to those things. But whatever's coming down the pike, based on my experience with the governor thus far, I know that it's going to be something that has been discussed among the medical experts who are helping to drive the effect of the direction and to gauge the impact of these decisions. And it's going to be after a lot of consultation and deliberation. So with that, I will consider your question answered unless there's something that I forgot to speak to.
Yes, thank you for that. One of the main topics from the questions that we got submitted was about workers' compensation administrative hearings, and that in Las Vegas no hearings are being held, and in Carson City they're just voluntary telephonic hearings. Is there any information or insight that any of our speakers could give to what folks in the workers' compensation field should be looking for, thinking about as we move forward?
This is Linda Bell. I think that's really outside of what we can do as a court. Those are administrative positions that are not part of our system.
Okay. Some of the other questions, and just to remind people that are on the phone, I know the original intent of the call was for the original directive, which was a lot more broad, and the revised directive is much more specific. So if you have other questions that our speakers might be able to help you with, you can hit 5* to show that you have a question. But one of the other, I guess, broader topics that was in the questions that were submitted was how we can continue to move our cases forward by remote means, and if there would be any encouragement or directives for video to be used or telephonic means to be used for arbitration or depositions, so that we can continue moving our cases forward while still, respecting the health and safety of the individuals involved.
This is Chris Pickering, and I will say that the Nevada Rules of Civil Procedure make express provision for video depositions, and certainly, I recognize that different cases have different requirements, and public health is more important than, is crucially important here, but there may be instances where a video will not be adequate, and I'm hoping and trusting that lawyers are agreeing among themselves to try to navigate those cases. But certainly, if you can do a remote deposition and not put people in the same room together and risk health crises, the rules allow it, and I personally would encourage it. And I think my colleagues on the bench would agree with that.
This is Linda Bell. I agree with that. In fact, in our administrative order related to civil cases, we encourage things like completing 16.1 conferences by telephone, doing Rule 16 conferences by alternative means. If the parties can agree moving forward with items of discovery, understanding that there are going to be a lot of situations where people are not available. Experts may be busy handling healthcare things. There may be people who are ill and unable to manage that. So we tried to balance out in our administrative order the ability to get at least a little bit done because we know it's going to be very challenging on the other end of this, given our very high caseloads to manage, basically doing double work for some period of time. We are not doing settlement conferences right now. That's one thing that just seems to not work great. But if somebody does want to do a settlement conference by alternative means, I know there's judges that are willing to do them if you think it would be effective in a case. So that's one possibility for trying to move things forward. It's possible to do a bench trial by alternative means. I do think that poses some challenges, and I'm not sure that any of our judges have done a bench trial yet completely by alternative means, other than in our family division where they are doing some divorce trials.
And I'll just share at the second. Obviously, our population is somewhat distinguishable from the 8th. We're moving more at a snail's pace, quite frankly, because our volume is less than in the 8th. I certainly respect everything Judge Bell is doing. What we're doing is having cases move forward as they should and as they can, given this environment. But as I said previously, I'm leaving it to the department's discretion as they weigh as a priority the current pandemic versus the priority for the particular case on a case-by-case basis to move forward, whatever that means. And so certainly deadlines by stipulation are being respected, but we are giving liberal continuances based upon circumstances, hopefully with very little prejudice to the parties stipulating during this challenging time.
One of the questions that we had from some of our members was, and you may or may not be able to answer this, is if we have any idea the anticipated start date when we will begin having jury trials again, and if the parties had previously requested a jury trial but want to stipulate to a bench trial and maybe conduct it by alternative means, if that would be an option that either of the courts would be open to.
That option is provided for in our administrative order.
In the second, we have, no real objection to that, with the exception that there is no date that I can possibly project where we'll do jury trials in the near future by their very nature and how we need to pick juries and assemble potential veneermen. As far as bench trials are concerned, we've been trying to explore what that would look like with our current technological world by Zoom. And it's certainly in the realm of possibility, but nothing has been refined in the Second Judicial District at this point for a bench trial.
This is Aaron Ford. This is a prime example of types of questions that obviously, I'm not able to answer or refer to. Again, this is the reason why the governor wanted to clarify that his order related only to statute of limitations, which are within his authority to address, and not court rules and procedures and processes and things of that sort. I will say this, though. I know that the two branches represented here have the same concern and the same issue, and that's ensuring that we can mitigate, because we know we can't eliminate, but mitigate the issues that COVID-19 are presenting to us. And we're learning new things about the way it's spread all the time. We're hearing about asymptomatic folks spreading the virus. We're hearing about the virus being able to survive on services for up to durations of time that we didn't otherwise know about. And so, as we proceed through this, understanding that we're all again having to respond to the newest information as it comes to us, we're asking for patience on this. I know a lot of folks want to get, for example, workman's comp cases moving and other types of things of that sort. And I think what we're seeing here are people. I'll give you a prime example. In my office, I'm in my office right now, but I'm one of maybe 10 people. I have 400 folks who work for me, and I have instituted a virtually mandatory teleworking/admin leave policy to ensure that we are doing our part, especially under the most recent order to stay home. So, we are cautious of what we're doing and cognizant of the fact that people want to stay safe, and we don't know how everything is spread. I would just continue to reiterate on this phone call that's our primary concern here. And we know that it's going to cause delays. We know that it's going to cause anxiety, but we're doing the best that we can under the circumstances as they're presented to us.
Thank you. I think some of our participants have chimed in with questions, so I think your lines might start to get unmuted. So if you hear line unmuted, that means you can go forward with your question.
Yeah, my question deals with situations where we have an out-of-state witness, a law firm, defense law firm, either in-state or in another state, and what we're consistently hearing is we are not going to do depositions, we can't meet our clients face-to-face, and frankly, that's not a workable solution. We need to be able to move our cases forward. So I'm just wondering what the process is at the Second and Eighth Judicial that we can raise these issues and try and create agreements on how depositions are going to proceed during this period.
Well, I'll take a stab at it from the second. First, one has to identify the need and priority, and please forgive me for repeating that sort of theme, the need and priority for the case to move forward, first of all. Are there specific examples or circumstances is a better word, where there's a need for the deposition to go forward in the face of the pandemic challenges we're dealing with? Let's assume for the sake of our conversation that you've been able to identify that. Then on a case-by-case basis, you probably would set forth that good cause and the necessity for that deposition to move forward within the good cause, and let the court decide if the other side is unwilling to participate or cooperate pursuant to our rules, and find out what their reasons are why they're not participating, and then the judge will have to make a call. Because my concern, at least as the chief of the second, I don't want to speak for Judge Bell, but we've had conversations. My concern, of course, is that as the death toll continues to rise, and especially in April, they think that the curve is going to be at its height this month. That as we move forward in that regard, I continually think about, as Attorney General Ford said, the health of the community as we prioritize our cases. So as I share with you, and it sounds like it's you, Mr. Sharp, and I always respect your work in my court, that you identify your priority by, if you need to file a motion, let me know. Let us know what the priority is and why you need it, and give us the cause so we could potentially evaluate with all things considered. I hope that answers your question from the second. It does.
In our administrative order from the 8th provides that upon agreement of the parties and the deponent, the in-person requirement of NRCP 28 and 30B5, which requires a deponent to appear before an officer appointed or designated to administer oaths and take testimony, may be modified, adjusted for social distancing requirements, or waived. However, if no stipulation or other agreement can be reached by the parties, there shall be no in-person deposition conducted while this is effective. I mean, our intention is, if everybody agrees and everybody's comfortable doing a deposition by alternative means where nobody's health is being risked, that's great. If not, most of our cases are going to be okay. If we have to go, 90 or 100 days without doing a deposition, it's going to take quite some time to get back up to speed with trials. And frankly, we have criminal defendants who are in custody who are not having their cases tried, and those are going to have to take precedence over everything else when we start retrying jury trials. So, most of our trials, the civil trials, are going to likely be tried later down the road anyhow. I don't think it's worth, I don't think a deposition is worth risking anybody's health, which is, while we would like to move forward pieces of cases as we can, our first priority always is to make sure that everyone is safe and healthy.
This is Herb Santos. I was gonna unmute my line because my question was answered, but if I can just make a quick comment, I don't think this happens in other states in terms of having the availability of you folks to talk to us, to help us be able to talk to our clients. So this, on behalf of all of my clients, and I know the members of NJA, thank you very much for taking the time out of your schedules to be here with us today.
My pleasure. Thanks for having me.
Chris Pickering, thank you so much, Herb.
Hi, it's VC. We do have a few more questions on the line, so we will continue to unmute your lines as we go through the list. So don't be shy, everybody. Go ahead and hit star or 5-star.
Hi. My question is about the statutes of limitations, Section 2. I just wanted to make sure that it can be read this way, but I could see an argument to the contrary. We focus on construction defect actions, so I wanted to be sure that it applies to statutes of repose and also applies to the filing of statutory actions, not just legal actions.
This is Aaron Ford. Yeah, the phraseology used there, any specific time limit set by state statute or regulation was by design. Understanding that there are statutes of repose, statutes of limitations, and maybe statutes of, other limitation statutes and regulations that I can't think of right now. So that is the intent. Again, the intent of the governor here is to ensure that folks don't lose an opportunity to pursue a cause of action because of the COVID epidemic. So that's the answer to your question.
Great. Thank you very much. And I echo Mr. Santos' comments a second ago. Thank you.
You're welcome.
Hi, this is Sean Claggett. I want to also thank all of you for being on this call. It obviously is helping us. My question is, this, and I know the 8th Judicial has the directive or the rule that was out there that Judge Bell just explained. But if we have a situation where this is going to be prolonged and it's going to go April, May, we have clients that, plaintiffs that are going to die. We have some really, sick clients as a result of what happened to them. At what point do you allow the defense to continue to take the position that, well, I'm not going to agree to do a remote deposition because I want the court, because for whatever reason, and it doesn't seem in today's technology that when these rules were written candidly, they took into account that we could have video conferencing. The need to have the court reporter in the actual room, I think, is much less today than when the rules were originally drafted. But at some point, is there going to be a possible, or have there been discussions about looking into the rule to say, hey, it doesn't need to be stipulated. You can do these depositions. And this is the way maybe it has to be done, and maybe this has to be done this way for the next 6 months. Who knows? But, at some point, I appreciate the pandemic, but we also have clients that at some point, if we don't get their depositions done, then it's not going to be preserved.
So I think this is Linda Bell, the first administrative order, and I know there's a lot of them, unfortunately, but the first administrative order, ours 20-1, allows a district court judge to determine that any case can be essential. So I think this is where what Judge Freeman said earlier comes in. If you have a particular case where there is a compelling need to move it forward, I would file a motion in front of the judge that has the case, because they all have the ability to make those determinations that there is a particular case that needs to move forward because of the circumstances of the case.
Okay, thank you.
Hi, this is Jessica Goody. I want to echo all of the thank you and appreciation for you guys taking the time out of your day to give us this information. It's incredibly helpful. The last time we had this call, it was pretty clear that the administrative order from the 8th District didn't apply to jurisdictional issues, including statute of limitations, trial de novos, and arbitration cases. Is there anything in the governor's directive that addresses or would be applied to the time for trial de novos in the arbitration cases?
I'm sorry, can you repeat that?
Does the governor's directive apply to the time for trial de novos in arbitration cases?
That's a good question, and I don't know the answer to that. So why don't we take that down and get back at you? Any specific? Yeah, let me get back at you on that one, okay?
Thank you.
This is Benjamin Childs. Is somebody going to address the policy in family court to have the relation back to the child support adjustment be the date when the motion is filed? Because a lot of people, this is going to get delayed till May or June before they realize that, hey, my child support is still accruing. And it seems like that would be prejudicial to just say, well, we're not going to adjust the child support until the date that you file the motion. Thank you. In other words, it ought to go back to like March or February when they lose their job.
I don't think I have an answer for that one either. I mean, again, the intent for Section 2 was only to talk about the commencement of cause of actions in court. So I'm not certain that I have an answer beyond that one.
This is Rob Murdoch for General Ford. I'm having an issue with the 30 days, especially in med-mal cases, because, for example, in med-mals, we have to get all the medical records, shoot everything to an expert, have the expert draft an affidavit, and the reality is, these days, I can't get medical records, and I certainly don't want to tax the system either. I don't want to start, complaining to hospitals I'm not getting records. They're a little too busy for that. And also getting experts and everything. So I think my issue is with the 30 days. It's just not sufficient, no disrespect intended, especially for the med-mal cases. So I was hoping you could talk about that. And also, in terms of Justice Pickering, I was hopeful you could think about maybe waiving 41E, the 5-year rule, at least for the time period of the emergency, so we don't have that issue hanging over our heads, years from now or even coming up.
This is Chris Pickering, and I can address the 41E issue. The orders in the 11 district courts across the state suspended 41E that have been entered, and I co-signed those orders on an emergency basis. If you've got a case that's set for jury trial and you can't bring it to jury trial because the courts aren't conducting them, 41E should not prevent you from later trying that case. So it has been extended and suspended, but I think tying it to the 30 days after the expiration of the emergency, we're going to have to address that. How long is that suspension going to last? Because right now the immediate orders went into effect as quickly as we could get them. So, for example, Judge Bell and I co-signed the first of her orders. We addressed the two obvious issues of 41E and on the criminal side, Speedy Trial Act suspensions, but we didn't address how long this is going to last or what happens when those suspensions expire. So that's very much, out there and needs to be addressed. But for right now, the 41E provisions, and that's on the judiciary side of the House as opposed to the statute of limitations, which is on the executive or legislative side of the House. We're aware of it, and we've suspended it. And I believe the second has as well. I can't bring to mind their order, but I think they suspended 41E as well.
And on the issue of the 30 days versus some other number, I hear you, and I'm not certain that, I'll say it this way. The first draft said that it expired with no grace period. So it's better than what was initially suggested. I'll say it that way. And, I don't know if the governor's going to have an appetite to extend that. Your point's duly noted. But again, with what he's trying to do here, to the extent that there's work that can be done in between now and then, obviously it should continue. But I think the 30 days was what he felt comfortable with at this juncture in terms of the statute of limitations issue.
Thank you.
Hi, this is Andrea Vieira. I'm a student at Boyd, and there's quite a few other law students on this call. We're set to graduate in May, and we had a question directed to Justice Pickering and AG Ford. I know this wasn't part of what you were scheduled to talk about, but there is some uncertainty regarding the July bar exam, and I know that several states are canceling their bar exam, and we're just hoping to get some information from you about if you have a deadline to make a decision about our bar exam, what your analysis is, perhaps any options that are being considered, and would this decision fall under the governor's emergency powers? Thank you.
This is Chris Pickering, and I have spoken to both Rick Trachuk and Paul Mattioni, and as of today, they're both aware of the bar exam issue and that other states have suspended it, and they're talking with one another about whether to do the same in Nevada. I did send a letter, and it was distributed to the new admittees suspending the swearing-in ceremony for next month for the people who took the February bar. And I know that they know because I talked to them about it, that that's an urgent issue that they need to resolve, whether they're going to hold that bar exam as scheduled or postpone it. And they are talking about it, and as of right now, I don't think they've come to a decision. And it's a fair question to say when is the deadline for them to come to that decision, and I'll follow up on that with them.
Yeah, and this is Aaron Ford. I don't have much to offer beyond what the Justice did. I can say this, whether it falls within the governor's executive authority or not, I can say that he does not like to step on toes, and if things are happening right now, as it sounds like they are, then he's going to want to offer deference to that particular entity in order to make a decision in that regard. So, I'll leave it there. We have to do research. For example, in the instance we're talking about right now, statute of limitations versus court rules, that's a separation of powers issue that we have to concern ourselves with. And so researching that, we want to be certain that we are narrowly tailoring what we're doing, and comparably not knowing enough about, I took the bar 20 years ago, however long ago, not knowing enough about its makeup and its interactions with executive, legislative / judicial. I don't want to opine as to whether he can do anything, but even if he could, as I've indicated, he's going to want to defer to the decision makers there if they're already considering those issues.
This is Kent Robinson. First, the respect and for human life and health that the judiciary, governor, and general showing is truly inspiring to all of us, and we thank you. We're having issues in our world with personal service of complaints and applications for temporary restraining orders. Is there going to be an administrative order or some kind of interim order that addresses that? Because we certainly don't want process servers endangering the health of those that have to be personally served.
This is Chris Pickering, and I'll take that question. I don't know the answer to it, but I share your concern, Kent, on that. And I know that the second has been working to make sure that people don't think they need to come down to the courthouse to get a summons issued and physically pick it up. Both the second and the eighth are electronically issuing them. I think it's Rule 4 talks about 120 days for service of a summons, and my particular view is that in this COVID-19 environment, people are in their homes, and we don't know who's carrying it and who's safe and who isn't, and I think to some people it would be alarming to have a process server come to their homes. There's a group of lawyers that was pretty much a small fraction of the NRCP revision committee that we put together on the amended rules, and we're looking at suggesting an extension on that particular rule from 120 to 180 or 220. And I don't know where that's going yet, but I think the courts are all mindful that those deadlines need to be able to be extended, because I can't imagine. I can imagine something terrible happening with a process server trying to serve process on somebody who's cloistered in their house and fearful and anxious. So if that's your concern, we're trying to address it, and I believe every district court in the state is going to be liberally granting extensions on the 120-day service. The problem is if you make a rule that automatically extends it, is that going to be a good one-size-fits-all for everybody? I don't know. So right now you can make a motion to extend it, and I think most courts would grant it, but there is a study committee that's looking at automatically extending a few of those deadlines, and that's one of them. Does that answer your question? Yeah.
Well,
Hi, it's Teresa Haar. There have been a couple of questions. I apologize. I've been on the mute, so I couldn't answer them as they came up. But there was a question about filing for a trial de novo for arbitration. There was a question earlier about an injured worker being able to file a workers' comp claim, for example. But nothing in the extension of the statute of limitations precludes or prohibits filing of any of these. It just gives an additional 30 days as a courtesy beyond the extension of the state of emergency. And so if anyone is going through an arbitration and does want to file a trial de novo after rejecting the arbitration award, they're certainly free to do so. Same with an injured worker who wants to file a claim. There's nothing preventing them from doing so.
I think this is Linda. I think the issue with the trial de novo was more a concern on the other side, was whether the governor's directive applies to applications for trial de novo after arbitration.
So I read it as if there was no prior action pending, and so it would have to be filed as a new complaint versus having an extension of time for filing into a pre-existing case. But I don't think there's anything prohibiting any of that would come from this. It's just I don't know whether it was intended to grant an extension for trials de novo as if it was an initiation of a new case or not. That's something that I'll certainly flag for the governor's office, though.
Teresa, this is Victoria. If you will go ahead and just keep we will not remute your line. We'll keep you there because I think we're going to have more questions for you here in a moment.
Okay.
So we're still unmuting lines. We still have several queues we have queues in the queue. Becky, go ahead and keep unmuting, folks. While we wait for our next line to get unmuted, I did want to remind everybody that these calls are being recorded, and they will be loaded on NJA's website. We also have almost 200 people on this call, so it does take a little bit of time to find all of the lines that we need to unmute. Oh, and with that, we realized we just answered our last question. So, Alison, if you want to wait a minute or go to any closing remarks.
Yeah, I think that, a lot of the questions that were submitted ahead of time were answered by the revised directive. And all of the directives and the administrative orders are on NJA's website. So if you have questions or can't keep track of them, like I know probably a lot of us are getting inundated with new updates and emails, if you go to the NJA website, it's there. And if there's anything that we can do for you as an organization, or if there's issues that come up, please let us know. We're here to help you during this time. I know we're all kind of struggling through in different ways, and we really appreciate all of our speakers. I know a lot of people have said this already, but really appreciate all of our speakers taking the time. And I just got a text that we have one more question, so we'll take one more question and then we'll wrap up the call for today.
We're working on it. I think we're good to go.
Okay. Well, thank you everyone for participating. Thank you especially to our speakers. And I know I speak for all of NJA when I say, please stay healthy and check on each other. Make sure your friends, your coworkers, your colleagues are doing well. And if there's anything that we can do as an organization or personally, please reach out to us and let us know what we can do to help you.
Thanks so much.
Thank you very much.
Thank you.
Thank you very much.
Really appreciate you guys. Thank you so much. And thanks to all our members who called in. Take care.
Bye-bye.